Hello, friends. This is Amol, and I hope all of you are doing well and keeping safe during these difficult times. Today, in this third episode of Sunday Boosters, we will discuss bank guarantee clause in a commercial contract and try and understand how a council can identify commercial side of the contract and make it mutually win-win clause. The provisions of Section 126 of the Indian Contract Act define the contract of guarantee as follows. A contract of guarantee is a contract to perform the promise or discharge the liability of a third person in case of his default. The person who gives the guarantee is called as surety. The person in respect of whose default the guarantee is given is called the principal debtor, and the person to whom the guarantee is given is called the creditor. It also says that a guarantee may be either oral or written. Now, if we carefully look at the provision, we'll see that there are three essential parts to this definition. First, there are three parties involved in a contract of guarantee: a surety, one who is making a promise; two, a principal debtor, on behalf of whom the promise is made by the surety; and third, creditor. That's the person who has received the guarantee. The second important element is existence of a contract. There has to be a contract between these three parties where surety, principal debtor, and creditor have agreed to do certain things. The contract may be oral or written, but it has to be a contract. Uh, Third important thing is event of a default. Now, typically, a bank guarantee or a contract of guarantee will come into play only when there is a default. If two parties, that is, principal debtor and creditor, complete their mutual obligations, there is no occasion for the surety to satisfy the promise. And therefore, in a contract of guarantee, event of default is also a very important element. Also, we need to consider the provisions of Section 127 of the Indian Contract Act, which typically talk about what is exactly the consideration for the contract of guarantee. It says that anything done or any promise made for the benefit of the principal debtor may be a sufficient consideration to the surety for giving the guarantee. Now, let us try and understand this through an example. In a contract, B requests A to sell and deliver to him certain goods on credit. A agrees to do so, provided C will guarantee the payment of the price of the goods in case of failure of B. Now, C's promise to guarantee the payment is sufficient consideration for the contract of guarantee. What is happening here is B is requesting delivery of goods on credit. A is agreeing to deliver the goods on credit provided C is guaranteeing the payment in case of B's failure. So C is the surety who is kind of guaranteeing the payment. B, who has received the goods on credit, is a principal debtor, and A, who has delivered the goods, is a creditor. As you all know, in a contract, consideration is an essential element. In the context of above example that we just saw, a contract between A, B, and C, B is promised to deliver the goods on credit if C guarantees payment is sufficient consideration. Now, taking the same example, or rather say taking the same concept into account, let us try and understand the contract which involves bank guarantee. A lot of commercial contracts have a built-in clause for bank guarantee, which essentially tries to cover the payment obligations in a contract and tries to cover up for the mutual commercial payment obligations of the parties. Now, in a contract of commercial contracts, bank guarantee is dealt via two separate documents. First document is a contract where two parties are agreeing on certain mutual obligations, and that contract involves a clause which has bank guarantee against certain deliverables. The second document is a tripartite bank guarantee agreement that is executed between these two parties who are parties to the first contract that we spoke and the bank. Now, in the bank guarantee contract, bank plays the role of a surety because it promises to make good the payments in case of an eventuality. One of the parties, other than bank obviously, who needs to carry out certain obligations is the principal debtor, and the party who is supposed to receive the services and the money is a creditor. So, in a recently passed Supreme Court judgment, I can give you this citation also. It's between Standard Chartered Bank versus Heavy Engineering Corporation Limited. It's 2020 SCC 574 case. The Supreme Court had held that a bank guarantee is an independent contract between the bank and the beneficiary, and the bank is always obliged to honor its guarantee as long as it is an unconditional and irrevocable bank guarantee. Further, the dispute between the beneficiary and the party as whose instance the bank has given the guarantee is immaterial and is of no consequence. So we must understand that once we give a bank guarantee which is unconditional and irrevocable, bank has no role to deny the payment if the creditor comes asking for that payment. And that's what has been held in this judgment. Now let us try and understand a few commercial angles attached to the bank guarantee as well. Typically, a bank will not give you a guarantee for free, right? So in consideration for bank guaranteeing certain payments, principal debtor will have to mandatorily maintain certain account balances with the bank, which are either equal to or more than the amount which the bank has guaranteed. Also, the principal debtor will have to keep a lien on those accounts marked in favor of the bank. That's one commercial angle. Second is, if you're not keeping those account balances, then alternatively, you may want to keep, you in the sense the principal debtor will have to keep certain collaterals with the bank, which the bank can liquidate at a later date when it satisfies the guarantee amount. In both these cases, what is happening is certain amount from your capital or working capital is getting blocked for the entire tenure of the bank guarantee contract, because you are maintaining that balance constantly with the bank and you cannot utilize it for your business purposes. So your amount is getting sucked. Third commercial angle attached to the bank guarantees is bank also charges a fee for guaranteeing the payments. Now this fee ranges from and is different from bank to bank, but typically it is somewhere around 6% per annum kind of a charge that the bank charges. So that's another commercial angle attached to it. Also, because in most of the contracts the bank guarantees are unconditional and irrevocable, the principal debtor, say there is a dispute, what will happen is creditor will liquidate your bank guarantee, and in a way the principal debtor is funding the dispute against himself, because creditor is now sitting happy or sitting pretty with your own money, and you are fighting that dispute, spending your money behind that money which is already with the creditor, and that's costing you further. All these important commercial considerations will have an impact on your P&L and therefore have to be kept in mind when you as a counsel are looking at the bank guarantee clauses in an agreement. Let us try and understand this with an example. Whatever I have said, let's try and put it into a practical example. Party A and Party B enter into a sponsorship contract where Party B gets the rights of a title sponsor for a large entertainment event for a period of, say, 3 years. The contract requires Party B to make payments of sponsorship fee as per the payment schedule which is prescribed in the agreement, and it makes it liable for payment of sponsorship fee for each year in advance. Say, assuming 15th of January, on or before 15th of January every year. Now, the contract in this example also envisages that this advance payment of sponsorship fee is secured through an unconditional and irrevocable bank guarantee to the tune of gross sponsorship fee for the entire period of the contract. The contract also envisages that any breach other than the payment obligation and the breach of indemnities or breach of obligations which are covered by indemnities too are secured through the bank guarantee. Now, a close look of this clause would reveal that bank guarantee can be avoided for the following things, or at least the exposure for the principal debtor can be reduced a little bit, either to the quantum of the guarantee, which will result in quantum of costs that one will have to incur on those bank guarantees. What are those things which can have impact on the costs and charges that you are going to incur? First and the foremost thing, limit the guarantee only to the amount that are due for the next 12 months. See, the example already says that you are making the payments in advance. Now, at the beginning of the first year itself, when you are making payment for that particular year in advance, why would you want to protect 3 years payments through a bank guarantee as a gross? In a way, you are paying extra money for something which you for an obligation which you've already carried out. So you can reduce the bank guarantee amount and say that bank guarantee should only cover the next tranche of payment. So if there are 3 tranches of payment, the bank guarantee will cover the immediate next tranche of payment. That will reduce your quantum of bank guarantee and therefore even the costs that you'll have to incur on the bank guarantee. The second thing that you can look at is to guarantee to only cover the monetary obligation and no other obligation for which other legal remedies are available to the party. Now, why I'm saying this is, it's only the payment that is going to be secured by the bank guarantees. For any other breach, there'll obviously be a dispute which will have to be resolved between the parties amicably, or if they are not able to resolve amicably, then through a judicial body. Why should you fund that dispute through the bank guarantee, which is your money? So only the payment obligations should ideally be covered through the bank guarantees. Also, you can try and put in certain conditions like serving of a notice of breach, then prescription of a cure period for you to cure that breach, and only in case you still fail to cure that breach beyond the breach period should the creditor be able to liquidate your bank guarantees. So now you understand as to how every single point in a bank guarantee clause needs to be looked at from the point of view of a commercial angle as well, and understand the impact that the clause may have in case of a future dispute, so that you make your clause robust and a win-win clause for both the parties to the contract. Thank you so much.